Ladies and gentlemen, welcome back to my YouTube channel. I hope you're happy and you're healthy. My name is Constantinide and I'm bringing you today the final case of the trilogy in regards to the defense of consent, which is the case of R versus Emmett. Mr. Emmett was engaged in heterosexual sadomasochistic act with his partners, and to be more specific, what he was charged with is the fact that on the first occasion he tied up her head with a plastic bag, and then on the second occasion he would pour lighter fluid over her and set it alight. Now, the defendant, Mr. Emmett, was permitted to bring the defense of consent in the court in regards to his trial, in regards to the injuries that are sustained during the sexual consensual and sexual sadomasochistic act with his heterosexual partner. He was found guilty, and Mr. Emmett then appealed his conviction, but the Court of Appeal upheld his conviction. Essentially what that means, it means that he was indeed guilty for the offences that he committed in relation to inflicting bodily harm to his partner. Now, what the Court of Appeal said is that his partner could not lawfully consent to this kind of act. And I would quote as to what the learned judge said during his ruling is that in this case, the degree of actually potential harm was such, and the degree of unpredictability as to the injury was such to make it proper cause for criminal law to intervene. This was not tattooing, and it was not something which absented pain or dangerousness. And the agreed medical evidence in this case, certainly in the first occasion, which is about tying her head with a plastic bag, there was a considerable degree of danger of life, and on the second occasion there was a degree of injury to the body. Now, it is worth discussing the judgment, the feminist judgment from Baroness Mackenzie in regards to R versus Brown, that she questioned the relationship between the violence and sexuality in the eyes of the law. Now, Baroness Mackenzie, she gave a dissenting opinion in regards to R versus Brown in relation to the defense of consent, that it should be available to consensual sadomasochistic practices. She did explore and question the relationship between the violence and the sexuality, and the law responds to it. And she noted 2 points here which I would like to share with you, because I do believe it is quite important for us to actually drill down into the depth of this case in regards to the morality of it. The first one is that the central liberal legal thought that the state retains and should retain a monopoly in regards to the violence caused to the citizens. So the state is the one to actually be able to inflict violence. For example, police officers, they are allowed, and of course it is regulated. Now, the second point is that the feminists have divided the legitimacy of criminalizing sadomasochistic sexual activity, and that some of them, they argued that those who consent to such activity are suffering from sociopathological false consciousness, and others are seeking to affirm the capacity and the right of women to make informed decisions. Those are the 2 main points that Baroness Mackenzie, in her dissenting opinion, R versus Brown, discussed and explored. If you haven't watched, and if you're not aware of R versus Brown, please make sure to check it down in the comment section below. I did post a video, which is the first case that I've posted here in regards to the defense of consent. Also, I would like to touch upon what does it mean to be a practitioner of sadomasochism. Now, to be a practitioner of sadomasochism is to be a resistance fighter, and to assume identity and to express that identity in such a way. Literally, to be a practitioner of sadomasochism, it will be incomprehensible to a moderate and a moderating legal system which sees the responsibility as one of sustaining traditional heteronormative values. You may ask now the question as to do you believe that this is a right judgment? Do you believe that R versus Emmett followed indeed the R versus Brown? And my view is that R versus Brown and R versus Emmett were consistently followed in those cases, and R versus Wilson was distinguished because of the medical evidence that would have been provided in that case, and it was as simple as a matter of tattooing. So the wounding and the inflicting of harm was such that it would only be scrutinized under the eyes of law as to the extent of whether the consent would be available. But I think the most important point for us to take with us from the trilogy of this case cases that I've shared with you here, is that consent is not available as a defense when it comes into sexual gratification. And the feminist approach in the judgment of Baroness Mackenzie is such that maybe we should be looking into allowing the defense of consent to seep into the eyes of law, and allowing those people to wish to practice their femininity or their sexuality indeed, by allowing the consent of defense to be available. Now, let me know what your thoughts are. What do you think about the dissenting opinion of Baroness Mackenzie? Whether you believe that the feminist approach, which is the dissenting, so it wasn't adopted or followed, but nevertheless it forms part of the judgment, whether you believe that it is somehow allowing the patriarchy norm of society to be part of us by allowing the defense of consent not to be available in sexual activities. Let me know what your thoughts are. Let me know what you believe about it, and I will see you in my next video, and I hope you're well, and I will see you very soon. I love you loads. Take care. Bye bye.